Assalamu alaikum and a very good morning to you all. On behalf of Bangladesh International Arbitration Center and on my own behalf, I am very pleased to welcome the Honorable Chairman and members of the Arbitration Tribunal and also the students in the first ever BIAC Inter-University Arbitration Contest 2020, which is being held from today in the first round and will be followed by the second and final rounds on the next 2 consecutive Saturdays, 19 and 26 September 2020. Dear all, apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, especially arbitration, mediation, and negotiation to develop a pool of human resource in this field. Moreover, since its inception, BIAC has been working hard to create awareness about arbitration and mediation facilities by conducting several outreach programs, seminars, webinars, consultation sessions, workshops, and dialogues. Recently, we have taken initiatives of providing ADR training courses for university students, keeping in mind that they are our future leaders, businessmen, legal professionals, judges, academicians, corporate and government officials, to create a unique platform for students with a view to acclimatizing them with the norms, practices, and benefits of ADR in resolving commercial disputes. BIAC is offering students membership for those who want to be associated with BIAC and can contribute in the field of ADR. Nowadays, keeping in mind the importance and need of the global best practice of ADR, we have decided to expand our activities further, and as part of it, we have the privilege to launch this inter-university arbitration contest for students of law for the first time. From now on, BIAC will be hosting inter-university arbitration contest every year. This year, due to the COVID-19 pandemic, we are conducting the contest through virtual platform, but from the upcoming years, we plan and hope to conduct the contest upfront on BIAC premises. This year, 4 of the leading universities of Bangladesh are taking part in this contest, which are Dhaka University, the London College of Legal Studies, LCLS South, Independent University Bangladesh, IUB, and Buyan Academy. We distributed the 4 universities into 2 rounds, and the winner of the 2 consecutive rounds will compete in the final round. In each round, every team will consist of 4 to 6 students from each university. Each team will be comprised of students with the roles of coordinator, lawyers, witnesses, and parties representatives for their respective sides, and will be provided with 60 minutes to present their cases. Prizes will be awarded to the winning team, runners-up team, along with the best teamwork prize and the best participant prize. For the contest, we have formed an arbitration tribunal consisting of 3 members with prominent jurists and lawyers for each consecutive round. Today, we have the honor to have as our tribunal chairman, Mr. Justice Abdus Salam Mamun, who is a well-known jurist and a former judge of Supreme Court of Bangladesh. Along with him, today we have with us Barrister Ali Asif Khan, Advocate, Supreme Court of Bangladesh and Head of Chamber, Hossain and Khan Associates, and Barrister M.D. Monzur Rabbi, Advocate, Supreme Court of Bangladesh and Head of Chambers, Rahman and Rabbi Legal as members of the tribunal. Today, for the first round, we have London College of Legal Studies, LCLS South, as the claimant team and University of Dhaka as the respondent team competing against each other. Now it is time to start the contest, and I would like to hand over the stage to the chairman of the tribunal, Justice Abdus Salam Mamun sir, to start and run the contest. Best of luck to both of the teams.
Thank you very much. Bangladesh International Arbitration Center, BIAC, generally arrange this type of arbitration with given premises and problem, and to find out solutions from the participants. And this is being a long practice of Bangladesh International Arbitration Center. And today we are now participating in such a meeting. I hope the two arbitrators are present with me, and the participants are also present. And we are ready to start the meeting. Calling for the claimant, giving them first opportunity to place their claim before the arbitral tribunal. So it is the turn of London College of Legal Studies, South.
Good morning, Honorable Arbitration Panel. Hope you are doing well in these turbulent times. My name is Nafeez Imtiaz Araf. I am the counsel representing the claimant Megadrive Limited. Assisting me today would be my co-counsels Maimuna Chaudhary and Shah Mohammad Rafi. Shah Mohammad Rafi would be handling examination of the claimant's witnesses, and Maimuna Chaudhary would be handling the cross-examination of the respondent's witnesses. Before we move on, would the Honorable Arbitration Panel like a brief summary of the facts of the case?
Yes.
Yes, please.
Please start.
Sir?
Yes, please go on.
Hello?
Do you hear me, please?
Yes, all right.
So,
Apologies.
yes, please, you
Much
can
obliged.
proceed.
Sir, it is humbly submitted by the claimant that on the 5th of October 2017, Dhaka City Corporation invited an international tender for 6 specialized search and rescue equipment. The deadline of submission of that bid of tender was 20th of December 2018. The principal, upon consultation with the local agent, had raised a bid of $1.8 million on the day of the deadline. The local agent had also provided a bid bond of $5 million 2 days before the deadline and attached it to the bid upon earnest request from the principal, so as to prevent the principal from facing any financial exposure whatsoever. The principal and the local agent have had an agreement that there was to be an undisclosed margin of 15% of the total contract value. In this case, the total contract value being $1.8 million between the principal and the Dhaka City and the Urban Resilience Project of the Dhaka City Corporation. And 15% of this equates to $270,000. This is to be paid to the local agent. For their services. These services, this payment included fees for custom clearance, port handling and charges, inland transportation, transit insurance, and much more. The letter of acceptance of the tender was issued by Dhaka City Corporation to the principal on the 3rd of June 2019. The performance bond constituting 10% of the total contractual price amounting to total contractual price was issued via Prima Bank by the principal on 3rd of July 2019 for the event that if there was a delay or failed performance in 2019, The terms of this contract included a warranty of 1 year free servicing of the equipment. It also required Dhaka City Corporation issue an irrevocable letter of credit in favor of the principal for 100% of contract value. The contract and the letter of credit requires 80% of the total contract value to be paid to the principal when the shipping documents are presented, and the rest of the 20% to be paid after DCC receives the equipment. An agreement between the principal, the respondent, and the local agent, the claimant, was also constituted on the same day, which stated, called the Agreement on Allowance and Commission, which stated that within 7 days of receiving this 80% of the total contract price from the DCC, the principal would pay it without further communication to the local agent. The principal received the contract, received their payment of 80% on the 25th of April 2020. 7 days, meaning on the 22nd of May, this value was due to the local agent, but only 100,000 US dollars of the due 216,000 US dollars was received, that too on the 30th of May, 28 days after the payment became due. To make matters worse, despite continuous reminders and requests through email by the local agent, my client, only US $9,000 was paid with the principal, that too on the 7th of July 2020. Amicable means of recovering the money had been done. The claimant have been patient, but as of 12th of September 2020, that is today, the payment of still 107,000 US dollars is still overdue from the principal to the claimant. That is a brief summary of the facts of the case so far. May the counsel now move on to the legal pleadings.
Yes.
Much obliged. The counsel would like to submit on a number of things. First of all, the counsel would like to submit that the arbitration tribunal today does indeed have proper jurisdiction. The counsel would also clarify on the laws that govern, on the laws that relate to this arbitration agreement. The counsel would also, in his closing statement, clarify on the contract between the principal and the local agent, whether there was indeed a breach, and what remedies are to be due to the claimant. But at the start, the counsel would like to clarify that indeed the arbitration tribunal has jurisdiction to hear the dispute at hand. The choice, first of all, the counsel humbly submits before the honorable arbitration panel that the arbitration procedure as per section 1(2) of the BIAC Arbitration Rules 2019 is indeed valid, and the BIAC Arbitration Rules 2019 apply with relation to the arbitration procedure. For in the agreement of allowances and commission, the clause clearly states that BIAC will administer the arbitration, and therefore applying section 1 to the BIAC arbitration rules, such rules shall apply to govern the arbitration procedure. With regards to what law shall govern the arbitration agreement itself, the counsel would now like to submit that the Arbitration Act 2001 of Bangladesh shall apply, as section 3 of the act states all arbitration proceedings conducted within Bangladesh shall have the Arbitration Act applicable to them. The agreement on allowance and commission was signed on the 5th of July 2019 in Dhaka, Bangladesh, and therefore the counsel humbly submits that since it is an arbitration agreement formulated within the Bangladeshi jurisdiction, Bangladeshi Arbitration Act shall apply to govern it. Furthermore, it is also stated that as per section 17 of the BIAC arbitration rules, that sets the framework for the arbitration. It states in the absence of an agreement on what law should govern the arbitration agreement, or in the absence, that is, on the absence of an agreement on what the seat of arbitration should be, the default seat of arbitration shall be Dhaka. As per section 2.3 of the rules, the seat shall be defined as the jurisdiction under which the arbitration shall be held, further cementing the claimant's submission that indeed Bangladeshi law shall apply to govern the arbitration agreement. The council will now submit that in relation to the substantive contract, in this case, the agreement of allowances commission, Bangladeshi law shall apply. In the case of Sul America, as the Honorable Arbitration Panel shall find on page 9 of the arguments on behalf of the claimants, and para 1. In the case of Sul America, the English court has stated that where there was no choice of law clause in the agreement, the party's choice of seat was to be referred to determine the governing law as it had the closest and most real connection with the arbitration agreement. And such was mentioned in the seminal book of International Arbitration by Redfern. The contract was signed in Dhaka. As the council have previously justified, the seat of arbitration is Dhaka. Therefore, it is further submitted that the law governing the contract should also be Bangladeshi law. The council would also, for persuasive reasons, refer to the Convention on the Law Applicable to Contractual Obligations 1980. In Article 4.1 of the Convention, it is stated that in case a choice of law was not made in the contract shall be governed by the country with which it is most closely connected. Clarification of close connected is in Article 4.2 of the said convention, which states that close connectedness is defined as the country where the party shall execute the performance of the contract and has its central administration in it. The performance of the contract, majority of which is in Bangladesh. As in Bangladesh, the claimant, the local agent, would be delivering the product to the urban resilience project. All inland transportation and shipping formalities and custom clearance are to be handled, as well as the fact that the tender, the submission of the bid bond, and all agreements were signed in Bangladesh. And therefore, it is stated that it is submitted that the majority of the contract's performance is in relation to Bangladesh. Therefore, the council humbly further submits that indeed the substantive law that should apply is Bangladeshi law. And in this case, the Contract Act of Bangladesh of 1872. Section 23 of the BIAC arbitration rules, Section 23 of the BIAC arbitration rules empowers the tribunal to apply substantive law it deems appropriate. And in this instance, we humbly request the tribunal to find that the applicable law shall be Bangladeshi law in the substantive context after considering the aforementioned arguments. At this point, the council would like to ask whether the tribunal have any queries.
Yes. We find that after jurisdiction and seat of arbitral tribunal, you have annexed some evidence in the form of affidavit in support of your claim.
Yes, sir.
Whether you like to go for evidence.
Apologies, sir.
Are you willing to go for evidence?
Sir, would you allow the council just 2 more minutes to briefly mention the breach of contract and the remedies that we are asking before we move on to the evidence?
Yes, you can. It is
much obliged, Honorable Tribunal, Honorable Chairman. The council at this point would like to submit a number of things. Firstly, the council would like to submit that the arbitration procedure has been properly formulated. Furthermore, the council would like to submit that there was indeed an agreement, a contract, valid contract between the claimant and the respondent, as through the agreement on allowances and commission. As per Section 2N of the Contract Act 1872, a contract must be entered into free of consent by competent parties for lawful consideration and lawful object. It is submitted that the claimant and the respondent would not have been able to would not have been able to be members of directors of their respective companies if they were not of legal age, and therefore they were. It is submitted that they were parties who had the legal authority to be competent to enter into a contract. Lawful consideration was given and they entered into the contract free of consent, as they had both signed the contract, and nothing in the facts in the case file submits as such that there was any duress or fraud. It is further submitted that this said contract had a number of terms. One certain term in it was an express conditional term, which states that 80% of 80% of the fee due to the agent for the services that the agent, my client, the claimant, have provided and shall be providing is to be paid to him within 7 calendar days of receiving payment from the project, and that too without further communication. This was not, it is submitted, was not done as per the case file. Furthermore, the payment was done only partially and at dates and at a delayed date. Furthermore, it is submitted, therefore it is submitted that the respondent was in breach of this contract. It is also submitted that the claimant had performed their obligations by conducting all activities that were recorded of them as of the date of the hearing, and it is submitted that the respondent is liable to perform their promise, and we humbly submit before this tribunal to give us a relief of specific performance of the 107,000 that is still due to the claimant, as well as fees payable to BIAC, our lawyers, and an interest that the council shall justify in the closing arguments, the payment all of which to the claimant by the respondent. It is also humbly submitted that since this is a civil case, there is a balance of probabilities, and we humbly submit that in this instance, we humbly request the tribunal to find in our favor, and the respondent have the burden to prove that there was no contract, that there was no, which evidently it was, and that they also have to prove that they were not in breach of that same contract, which they evidently are, as we shall see through the evidence presented. With that, the council would now like to move on to the evidence that the tribunal chairman have mentioned.
Yes. You have claimed damages, and in your Article 18 of the Statement of Claim, you have claimed your outstanding dues and damages for delay and cost and inconvenience that you have endured. And relief sought, you have in gist has given reason for the reliefs. So what more you want to present before the tribunal?
What more apart from the evidence submitted so far?
No, we have gone through your statement of claim.
Yes, sir, Your Honor.
Your statement of claim, and thereafter what you want to add in support of the claim.
Apart from the exhibits, exhibits A to Q that we have submitted to the tribunal, the counsel at this point would like to query whether the chairman has received up till exhibit Q.
You have executed a contract with the respondent. Do you want to place the contract and the main terms and conditions of the contract?
Apologies. Apologies, Honorable Chairman, could you please repeat that?
You have executed a contract with the respondent for your commission.
Yes, sir.
And are you interested to place the basic points from your contract?
The counsel humbly submits that we simply want the contract to be executed as was previously mentioned. Since that was not done by the respondent so far, we simply ask for an interest or since the date that the payment was due to the claimant, and on top of it, we simply ask for $10,000 for damages for inconvenience caused to my client, Mega Drive Limited. Furthermore, we humbly submit to the tribunal that we simply ask, submit to the tribunal and request them to declare that the respondent is liable to pay for all fees payable by the claimant to BIAC and the lawyers. As if your honor would just give me a moment.
So your contention is that the respondent has committed breach of contract.
Yes, sir.
Now my brothers, arbitrators, if they have any question.
Yes, Mr. Nafis, could you take us to your particulars of claim? Could you refer to the relevant page number and the annexure where you have laid down the total value of your claim?
Much obliged, Sir Arbitrator. If you would give me a moment. The claims and the values are stated from page 22 of the arguments on behalf of claimants. I have described in depth all values through proper calculation from page 22 to page 30. In particular, on page 23, I have said why specific performance is applicable to the outstanding due of $107,000. On page 25, I have stated why the claimant is privy to the interest and the calculation of it. The interest, as the claimant have shown through calculation, amounts to 66,164.4 BDT for the 133 days from the 2nd of May that the amount is due. Furthermore, on page number 27, I have stated why the cost and fees of lawyers until full recovery of claim should be given to the claimant by the respondent, and I have referred to the case of Iran, United States Claims Tribunal. I have also stated on page number 28 the fees to be paid by the claimant to BIAC. These fees include 20,000 registration fee. It also includes It also includes administrative fees amounting to 38,159. This is on para 78. In para 79 on page 29, we have also stated the fees for the arbitrators amounting to 15,611,842.5 Bangladeshi taka. We've also stated we've made all these calculations within the ambit of Section 6 of the BIAC annexure of fees, and all calculations are made as such. And we have also asked in page number 29 that damages are and requested that damages be paid by the respondent to the claimant. Is there any further queries?
So just to be clear, the total amount due under the contract is $107,000 along with interest. What is the total amount then? If you calculate the contractual amount due, that's $107,000 plus the interest amount is?
Interest amount is 66,164 BDT. The contract amount, apologies.
The fee is 38,157.9.
Yes, Your Honor.
Okay, thank you. Thank you. Move on.
Sir, I would also like to clarify that.
Counsel, if I may intervene before you proceed further. I have looked at your arguments on behalf of the claimant, and as it is observed that you were asking for an interest at the rate of 2%. Am I right?
Your Honor.
Yes. What is the basis of this calculation?
If Your Honor would give me a moment.
And can you please take us to the particular portion of your statement of claimant?
Much obliged.
What have stated the basis of asking for interest at this rate?
Much obliged. If the Honorable Arbitration Panel would refer to page 25 of arguments on behalf of claimants, at para 74, I have stated that section 38(6) of the Arbitration Act 2001 empowers the tribunal to impose an interest on the award as it deems appropriate for the period between the cause of action, and in this case, the cause of action being the non-payment of the full fee on the 2nd of May 2020 to the day that the award shall be made, which is the council believes is today, the 12th of September 2020. And all calculations are made for this time period.
But why 2%? From where you got this figure? Because my understanding is that the tribunal has a discretionary power. Like, why are you indicating a specific rate? Do you have any provision of law that indicates the rate?
Much obliged, Honorable Tribunal. The council humbly submits that indeed the tribunal, the arbitration tribunal has complete discretion regarding the interest rate to be applied. We are simply submitting humbly that the 2% rate be applied as a request. Our justification, the claimant's justification for the 2% rate in this instance is that as apologies. If the Honorable Tribunal would give the council a moment.
You are explaining the reason why you claimed interest at the rate of 2%.
Yes.
That was the question.
Yes, the council would just like a moment. Yes, the council humbly submits that 2% is the rate that is commonly applied by BIAC, when it comes to as per the subsection 38(6) of the Arbitration Act 2001, the sum as per 38(6) of the Arbitration Act 2001, the tribunal obviously has a discretion to impose an interest on the award. As per the same subsection, the sum of the arbitral award shall carry an interest of 2% per annum from the day the award is made. The council, while he does not have the council simply refers to this and would and stating that the same be applied on the if a 2% interest is applied from the day the award is made till the day the award is eventually executed by the respondent. The council similarly submits that a similar interest as BIAC would apply to a late payment of an award be applied to an interest on the late payment of this of the instant late payment by respondent to the agent of their contract. That is the justification.
Uh, just a supplement to that, you have claimed USD 10,000 as damages, and the justification written in your request for arbitration is damages for time spent, inattention given, and inconvenience endured. So we understand that this general claim for damages. In your statement of claim, have you explained why you have claimed 10,000 US dollar as damages? Can you take us, please, to that portion of your statement of claim?
On page 99 of the arguments on behalf of claimants,
Please,
at
what?
page 29 of arguments on behalf of claimants,
Mhm.
with reference to paragraph 84, the council will humbly submit that it is not uncommon in international arbitration tribunal to award monetary compensation or damages for loss suffered by a party to a contract. While the council has not in this section stated exactly how the loss has occurred, in previous sections within the document, the council has shown through arguments that that the respondent had not paid the money when they were due. The council humbly submits that would like to supplement the document by stating that by stating that the money that the claimant is yet to receive, the claimant could have had to suffer and incur all expenses made by them till the date so far out of their own pocket. These are indeed damages and these are indeed inconveniences that they had to endure due to the respondent's violation of its legal obligation. While it has not been clearly stated in our argument on behalf of claimants, we are stating this on based on the arguments that we have put forth in this document, as well as the agreement on allowances and commission. The claimant also submits that the money that the claimant have the money that the claimant have was due could have been if the claimant was paid this money at the time that they were supposed to receive it, they could have invested it in other ventures, and the claimant would have been in a much more financially better off position. With reference to this, um, the claimant would also like to state that upon breach of a condition by a party, the injured party does have the right to affirm the contract and demand damages as per para 83. Therefore, since there was a breach of a condition by the respondent, the claimant furthermore submits that indeed the claimant has a right by default to receive damages. This is in footnote 28. The case was MSC Mediterranean Shipping Company versus Contonex and Salt on page 29.
Yes.
Does the Honorable Tribunal have any queries at this point?
No, nothing further from me. Thank you.
From my brothers. Yes.
At this point, may the claimant move on to the chief witness brought forth by them.
Any more question for clarification of the claim? I suppose the arbitrators are satisfied with the way you placed your claim, and substantiated it with the documents and the case laws. Now, the question remains, whether you are agreed to any consensus if the respondent agreed to pay your outstanding due 107,000 US dollars.
The respondent and the claimant.
Pays you.
Yes.
Whether you are agreed to any compromise or consensus, as they have used the term consensus, if they pay your outstanding due of 100,000 US dollar.
Honorable Chairman, the respondent have requested in their notice for arbitration for simply payment of 107,000 US dollars. However, the claimant does not agree to it. There is no consensus. The claimant would like further remedies, and as stated, of damages, of interest, of BIAC fees, and of lawyer fees, on top of the specific performance of the 107 US dollars. So no, there is no consensus between the respondent and the claimant.
Okay, we find that the parties had correspondence between them. You sent message through email and the respondent sent a message through email. Whether they agreed to pay this amount, 700,000 US dollar to you in their response.
The respondent had stated that they would pay within a very short amount of time, but they repeatedly, as we will see through the witness statements by our witnesses and through the emails that we have submitted, have repeatedly delayed the payment that they would be making. They had promised full payment, but then they have never fulfilled the promise that they made. Every time they had made repeated excuses, first of Ramadan and then of money laundering. All of these were unsubstantiated. For at the very core, the claimant would humbly like to submit that in the case file, it was mentioned that the case file is the entirety of the facts of the case. The claimant's majority of arguments go beyond what was stated in the state file. They have, the claimant humbly submits, have made logical inferences which are actually in reality completely logical. Their money laundering argument, their email chain are not to be found, nor are they properly based on the case file.
Good. Whether on any point of time the respondent denied your claim.
The respondent had at no honorable justice, the respondent have at no point denied our claim. They did say or mention that we were due, but they simply made excuses.
Yes. So any more question from my brothers? The arbitrators?
No.
Any question for clarification from the claimant?
Nothing further for me, Mr. Chairman.
Do you have any question?
Honorable panel, if it may please you, if you may humbly allow us to clarify the matters through examination in chief, unless further clarification is required.
Okay, please go ahead.
Much obliged.
Good morning, Honorable Tribunal Chair and respected arbitrators. My name is Shah Mohammad Rafi. I'm the second claimant counsel, and I shall be conducting the examination in chief of the claimant witnesses. Respected arbitrators and chair, with your permission, I'd like to call on the first claimant witness to give his witness deposition.
Yes, you can do that.
Much obliged. I hereby call claimant witness number 1 to give his witness deposition.
Yes.
Can you hear me?
Yeah.
Good. Could you please state your name and your profession?
I'm Tariq Ahmed, and I'm the managing director of Mega Drive Limited.
Mr. Tariq Ahmed, could you clarify the operations of Mega Drive Limited?
Well, we are a trading house that represents manufacturers and trading houses all around the world. So we basically work as the local agent.
Mr. Tariq, what is your connection to this dispute?
My job is to help facilitate trade in foreign locations, handling the logistical support and counseling with our clients. So it is for this that Brookfire LLC, which is a company, UAE-based company, they approached me for consultation purpose for securing a contract in Bangladesh on their behalf as local agent. So after the initial talking over the phone and email, on 9th of November 2018, we signed a memorandum of understanding with them in their pursuit of securing a bid on Dhaka City Corporation's urban resilience project.
Mr. Tariq, could you elaborate on the nature of the bid that you just mentioned?
We were trying to bid in the urban resilience project on 6 units of specialist search and rescue equipment breathing apparatus. And the total price bid of this amount was 1,800,000 US dollars, with each unit amounting to 300,000 US dollars. Now, this unit would be purchased and brought from the UAE to Bangladesh under CIP terms.
Mr. Tariq, what was Mega Drive's capacity in this bid?
As I've mentioned before, that Mega Drive acted as a local agent of Brookfire LLC, and we handle various local responsibilities along with any logistical, administrative, and general support that Brookfire LLC needed so that we can make sure that the bid was accepted by Dhaka City Corporation.
And Mr. Tariq, was that bid accepted by Dhaka City Corporation?
Yes, we successfully managed to get the bid accepted.
How did you prepare for the bid, Mr. Tariq?
Well, most importantly, what I used was my experience as in this industry to come up with a bid as good as I could and make sure that it got accepted by Dhaka City Corporation. The deadline of this bid was only 40 days away, and we managed to do it in that time. I should mention that other business and companies had more than a year to prepare for this bid, but we only did it in a matter of 40 days. On top of that, during the securing of the bid, at the earnest request of our principal, Brookfire LLC, and to shield them from any financial exposure, we even agreed to attach, and we did eventually, attach a bid bond of BDT 5 million on Dutch Bangla Bank as a bank guarantee to the bid, and which was only easily possible because of our previous dealings with the bank, and we had a very good relationship with them. And then finally, we entered into an agreement with Brookfire LLC on the same day that they entered a contract with the project, which is on 5th of July 2019.
Mr. Tariq, could you specify the terms of the agreement that you entered into with the respondent?
Well, the contract was called Agreement on Alliances and Commission, which stipulated a few terms and conditions. And one of the main terms was that our services, Mega Drive Limited is providing to Brookfire LLC, there is an express commission of 15% over the total same amount. And this
amount will be provided to us in lieu of our services handling local responsibilities, such as clearance of customs of 6 building apparatus, the port handling charges, and inland transportation from Chittagong to Dhaka. Furthermore, after the goods are received by Urban Resilience Project, Megadev Limited would arrange the training for the Dhaka City Corporation's employees so that they can handle the apparatus well, and then delivering them to their final destination at 6 different locations. We also provided administrative and logistical support to uphold the 1-year warranty as stipulated in the contract.
Mr. Tariq, you mentioned about a 15% commission. What was that 15% commission?
That 15% commission amounted to 270,000 US dollars. And it was explicitly mentioned in our agreement that 80% of this commission, which is 216,000 US dollars, will be provided to us within 7 days of Brookfire's receiving their payment from the project. And this should be done without any further communication. And as far as my knowledge, Brookfire LLC received their payment from the project on 25th April of this year. So we should have received our payment on 2nd of May.
Mr. Tariq, did you receive your payment within the due date as you mentioned?
No, I did not receive the payment on the due date, which is on 2nd of May. And to make an inquiry, I sent them a formal email on 10th of May asking about the payment. We still have not received our full payment as of yet, just got 2 installments till now.
So when was the first installment paid, Mr. Tariq?
The first installment was paid nearly after 1 month of the due date, which is on May 30. And that was even after contacting and emailing them a number of times, even though the payment should have been done without any further communication.
Mr. Tariq, how much was paid in the first installment?
In the first installment, they paid us 100,000 US dollars instead of 216,000 US dollars.
Mr. Tariq, how did you respond to that delayed payment?
I was acting on very good faith, as in, in business, a few days can be delayed when making a payment, but they actually assured me that I will receive my full payment soon. But receiving less than half payment was a red flag. And pursuant to this, I emailed them on 2nd of June that we agreed to wait for them to make the full payment on 5th of June as per their assurance.
So was that second installment paid by 5th of June?
No, I received no payment on 5th of June, even though they assured us. And after 1 month of waiting, I got a call from my bank on 7th of July that he received a payment from Brookfire LLC. And then I asked that what was the amount. And it was merely 9,000 US dollars. It does not accept me or my company. I mean, how can they even come up with the idea that they can pay us just 9,000 after all this time when they were supposed to pay us the full amount months ago?
Mr. Tariq, what actions did you take prior to and after that delayed second installment?
I was utterly shocked at their unprofessionalism, and it was so frustrating that even these 2 installments was received after continuous requests, reminders, and correspondence from our part, and they kept delaying the payment, and the emails were full of excuses, vague answers, and no concrete reason behind the delay of the payment. We provided our services with absolutely dedication and sincerity, and we invested our effort, money, and resources into this work. So my final action was just that I sent a formal email on 7th of July stating that they should pay the remaining amount soon. But even then, I didn't get any satisfactory response. So then I contacted my lawyers of peers and associates to initiate this arbitration proceeding.
Mr. Tariq, lastly, in relation to this agreement, how did you live up to your part?
40 days. We prepared a bid which takes years of others. And Megadev successfully got this bid accepted when there were other companies from Japan, Singapore, Germany, high-tech countries who could not procure this bid. But we did it for our principal Brookfire LLC. And we arranged the whole bid bond only for the benefit of Brookfire LLC and also at their earnest request. All the import documents, logistical support and consultation, everything that was needed, we provided that. So with all due respect, I believe that I have taken reasonable steps to amicably resolve this issue. But even patience has its own limits. And I just couldn't handle all their excuses anymore, and I was just done listening to that. So as the contract already had an arbitration clause, I thought that rather than going to the court of law, so it would be best if we request for arbitration so this matter can be resolved as soon as possible.
Thank you very much, Mr. Tariq. Honorable panel, no more questions asked.
Okay. We were supposed to start at 10:30 a.m., but we are a little bit late. And now 11 up to 11:30 it was your time, and we think you have concluded your claim. Is there anything more you to place?
No, sir, absolutely not.
Okay. Let us now hear from the respondents and their reply. Witness has been examined sufficiently. Unless they call for cross-examination, witness has sufficiently examined.
Mr. Chair and members of the tribunal, the respondent would like to cross-examine the witness.
Before cross-examination, whether the respondent is willing to place their own case.
With the permission of this tribunal, the respondent would like to cross-examine right away.
Yes, you have the opportunity for cross-examination. You will have the opportunity, but whether before cross-examination you want to place your case.
Yeah. Honorable Tribunal, yes, we'd like to place our case before the cross-examination.
The Dhaka University is the respondent.
Yes, Honorable Tribunal, the Dhaka University is the respondent. We'd like to start with our submissions if the court permits.
Yes.
Good morning, Honorable Chairman and members of the Tribunal. I, Bushra Haq, is a coordinator of the team from Department of Law, Dhaka University. The team represents respondent in the following matter: Megadrive Limited and Brookfire Engineering Industries. The team consists of 6 members, 3 lawyers, 2 witnesses, and a party representative. Mr. Sudipto Bhattacharya is present here as a party representative of the Brookfire Engineering Industries. The 3 lawyers who will plead for the respondent is currently working in the firm HRM and Associates, which is in Dubai, United Arab Emirates. They are respectively Mr. Ali Mashraf, Ms. Bushra Haq, and Mr. Rahman. Among the 2 witnesses, one is Mr. Abdul Hannan, who is currently the director in the business department of the famous company Brookfire Engineering Industry, and the other witness is Mr. Abed Nadir, who is the bank manager of the Tejgaon branch of Golden Bank Limited. The hearing procedure will be initiated by an opening statement by Mr. Ali Mashraf, which will be followed by direct examination of the 2 witnesses, Mr. Abdul Hannan and Mr. Abed Nadir, by Ms. Bushra Haq. Cross-examination, it will be conducted in two parts. Mr. Rahman will conduct the cross-examination of the first witness, Mr. Tariq Ahmed from the claimant side, which will be followed. Afterwards, there will be submissive arguments which will be submitted by Mr. Rahman. Now, if the Honorable Tribunal is well introduced to the team, I'd like to call Mr. Ali Mashraf to initiate with his opening statements.
Am I audible? Can I be heard?
Yes, okay.
Honorable Chairman and members of the Tribunal, I am Ali Mashraf from HRM and Associates representing my client Brookfire Engineering Industries LLC from UAE, today's respondents in this arbitration proceeding. Today we have a unique situation where in an agreement, the respondent has performed its obligations under the agreement. The failure to fully perform the obligation and the delay in performing the obligation, etc., the two charges brought by the claimant are also not due to my client's own fault, but occurred due to unforeseeable circumstances. Before heading into the factual issues relating to the agreement, let us first address the jurisdictional issues. Prior to that, we would like to agree that the summary of the facts provided by the claimant as of now is correct, and we have nothing further to add to the summaries. Going to the jurisdictional issues, we firstly submit that this tribunal indeed has the jurisdiction to hear this dispute. The last paragraph of the agreement on allowances and commissions, as provided in our exhibit E4, contains the arbitration clause that in case of any dispute, the matter shall be referred to BIAC Bangladesh, the International Arbitration Center, that is BIAC. The BIAC Arbitration Rules 2009, Rule 21.1.a states that an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. The same provision also empowers this tribunal to rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement.
Yes.
As such, we do abide and submit ourselves to the jurisdiction of this honorable tribunal. Secondly, let us deal with the substantive and the procedural laws applicable during the arbitration proceedings. On the issue of procedural law, we submit that for all intents and purposes to commence and conclude with this arbitration process, the tribunal should abide by the BIAC Arbitration Rules 2019 as the procedural law to determine this civil dispute raised by the claimant. The absence of any provision in the agreement of any other law for the time being in force in the two countries in this dispute, that is Bangladesh and UAE, makes it evident that the parties had no intention of bringing into action any other procedural law while a dispute raised could be settled. We are also aware of the claimant's claim that the Arbitration Act 2001 of Bangladesh, by dint of its Section 3, applies to this dispute. Hence, to clarify our stance, we urge the tribunal to primarily abide by BIAC Arbitration Rules 2019, and only in the event of any lacunae in the BIAC Arbitration Rules can it take recourse to Arbitration Act 2001 of Bangladesh. Now on to the question of procedural law. We first submit that the claimants in para 2, page 9 of the arguments refer to the Convention on the Law Applicable to Contractual Obligations 1980 as persuasive value in order to cement their claim that only the law of Bangladesh should be applied here. We would like to first submit, Honorable Tribunal, that the convention applies only to member states of the European Union, EU. Neither the claimant nor the respondent representing Bangladesh and UAE are members of EU and therefore are not bound even by the persuasive value of this convention, rather the jurisdictional value either. Rule 23.1 of BIAC Arbitration Rules states, the arbitration tribunal shall apply the rules of law designated by the parties as applicable to the substance of the dispute, failing which this arbitration tribunal shall apply the law which it determines to be appropriate. Honorable Tribunal, we also state that this same rule 23.3 states in all cases, the arbitration tribunal shall decide in accordance with the terms of the contract, if any, and shall take into account any usage of trade applicable to the transactions. Now, Honorable Tribunal, we humbly urge to you that this is a dispute arising out of an agreement between two parties who are from two specific countries, Bangladesh and UAE. Therefore, the substantive laws applicable in this dispute are those which govern the above mentioned activities between the two countries. That is, for example, the Contract Act 1872 of Bangladesh, the Civil Code of UAE, which determines contractual obligations and in itself has since this is a commercial dispute that is going on. Moreover, on the issue of the provision that which states of usage of trade applicable to this transaction, we submit to follow the banking laws of Bangladesh. That is the Bank Company Act 1991, as well as all circulars, notifications, memos, etc. issued by the Bangladesh Bank. Moreover, we submit that for interpretational purposes, the tribunal can hear our submission on the international law obligations of both UAE and Bangladesh. That is the conventions and international laws that they are party to or have signed or ratified or acceded to. And lastly, we humbly submit that to amicably settle the dispute, the tribunal can be flexible while applying legal provisions and take recourse to principles of equity if and when required. Thirdly, we submit that this arbitration procedure has been adhered to by both the claimant and the respondent. The claimants raised this proceeding pursuant to Rule 3 of the BIAC arbitration rules, and we responded to their claim as per Rule 4.1 and 4.2 of the said rules. We also would like to bring into your attention that we submit to being jointly liable with the claimant for any costs to be paid to BIAC arbitration tribunal for this arbitration proceeding as outlined in Rule 26 and 27, except for the specific damages, interests, and the claimant's legal fees. Now let us enter into the factual details of the agreement. We submit that the delay in paying the full amount was non-deliberate and caused due to factors beyond our control. My clients were unaware of the actual banking practices in Bangladesh, and hence there was a significant delay in the transfer of funds. This is the first time that my clients are entering into an agreement with a Bangladeshi business company. Bangladesh has scored very poorly in the ease of doing business index, ranking 168 as of date. We have mentioned this in exhibits E10, E11, E12, and E13 of our exhibits. My clients were unaware of the time taken for the clearance procedure and other administrative matters involving foreign currency transactions through telegraphic transfer, TT. Although on paper, Bangladesh Automated Clearing House clears transaction by 10 a.m. on the following day of the transaction, the practice says something different. Moreover, the payment time was during Ramadan, which contained limited banking hours. That's why while entering into the agreement, my clients had the term mentioned that they shall promptly and without further communication pay the agent / the claimants. This is to be characterized as a mistake of fact, and the definition of mistake of fact we are taking for persuasive value from Article 3.2.1 of the UNIDROIT Principles of International Commercial Contracts, which says a mistake must involve an erroneous assumption as to law or fact during the signing of contract. Provisions relating to mistake of fact and law both are mentioned too in sections 20, 21, and 22 of the Contract Act 1872 of Bangladesh. We further submit that Bangladesh Electronic Fund Transfer Network BFTN operating rules of 2014 in section 1.3 says that a delay of a bank or BEFTN is excused if there are circumstances beyond its measures. The respondent has already issued the transfer and that absolves it of the responsibilities. BFTN rules also absolve the bank and itself in the case of such delays. Lastly, submit under the issue of unforeseeable circumstances, Honorable Tribunal, that UAE is under the observation of the Financial Action Task Force FATF from April 2020 as evident from our exhibits 11, E12, E13. Thus, the transactions felt suspicious to the Bangladeshi bank. This led to the bank, which was supposed to debit the TT amount to the claimant's account, stop the payment and undertake specific administrative and security measures in line with the anti-money laundering and countering of financing of terrorism AML CFT guidelines 2015 issued by the Bangladesh Bank. This issue will be further supplemented through the direct examination of our second witness, Mr. Abed Nadir, during the examination process. Now let us move on to the fact that the respondent acted in good faith in their course of this agreement. If we refer section 3.20 of the General Clauses Act 1897 of Bangladesh, it says, a thing shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. Even the UAE Civil Code Article 246.1 says, contracts must be performed in a manner consistent with the requirements of good faith. All parties should, throughout the life of an agreement, act in good faith, whether it is expressly mentioned in the agreement or not. The respondent's act of furnishing performance security worth USD 180,000 by way of bank guarantee, as mentioned in page 2 of the agreement, the cumulative payment of USD 109,000 by July 7, 2020, I beg your pardon, and paying the residue amount as well, as stated earlier, which is yet to reach the claimant due to unforeseeable reasons and non-deliberate delays, prove the good faith in the performance of their obligations. However, it is very unfortunate that these unforeseeable delays and non-deliberate delays have been termed by the claimant as various pretexts and excuses bearing no relevance to the agreement. If we refer to you the ICSID case of Amco Asia Corporation versus Republic of Indonesia, the ICSID tribunal held that when interpreting a contract, one must look for the parties' common intention rather than simply restricting itself to examining the literal meaning of the terms used. We also refer to you the Dubai Federal Supreme Court's decision on June 7, 2010 in case number 556 of 2009 that in deciding whether an act constitutes bad faith, the court is to look whether a person exercised its rights unlawfully. And according to Article 106 of UAE Civil Code, the exercise of a right is deemed to be unlawful if the desired gain is disproportionate to the harm that will be suffered by the other party, or it exceeds the bounds of customs or practice. Honorable Tribunal, no act of the respondent constitutes such elements. At no point did my clients even gain anything financially while the payments were getting delayed. Rather, the goodwill was getting destroyed unintentionally. And this too was non-deliberate as mentioned earlier. We now move to a very central issue of the contract, whether time is of the essence or not. The claimants erroneously argue in para 46 in page 18 and 19 of their agreement that time is the essence of the agreement since it stipulates a date of payment by the respondent and they refer to section 55 first clause. However, Honorable Tribunal, if we refer to you the Bangladeshi case of Dulamia versus Haji Muhammad Ibrahim as reported in 1956 8 DLR page 616, it states that even fixation of the period of contract with power to treat it as cancelled if not fulfilled within time does not always make time the essence of a contract. The same principle was also held in Saradhani Kandappan versus Raja Lakshmi in the 2011 judgment of the Indian Supreme Court, with the same ratio decidendi that it depends on the facts and circumstances of each case where the contract contained provisions for extension of time and payment of damages in case of delay in execution of the contract, the parties did not intend that time was to be the essence of the contract. Now we submit your Honorable Tribunal that time was not indeed the essence of this particular agreement because there was no express mention of any circumstances that would occur if the payment was not done in time. The agreement remains silent. Therefore, it attracts the second clause of section 55, which states that if it was not the intention of parties that time should be of the essence of the contract does not become voidable, but the promisee is entitled to compensation from the promiser for any loss occasioned to him by such failure. Now comes the issue of any loss occasioned to him by such failure and whether they are entitled to compensation. Honorable Tribunal, we humbly submit that they are not entitled to any compensation or interest from us. Why so? Because Honorable Tribunal, despite receiving more than half of the payment under the agreement, which amounts to USD 109,000, the claimant have not performed their part of the obligation after receiving the payment. They even stated in their submissions that without the respondents paying the claimant, they use the word paying and not full payment, the claimant is not bound to carry out local responsibilities adhering to paying the claimant, and the claimant is not bound to carry out local responsibilities. Now, Honorable Tribunal, we humbly submit that since this is the case, they have not mentioned anywhere that they had indeed done some expenses, or due to such expenses, such losses went beyond 109,000. So when no expenditure occurred, when no losses incurred, the question of claiming damages for loss does not even arise. This rule can be found in the famous English case of Hadley versus Baxendale, where the House of Lords defined losses foreseeable in the contract law to be of two kinds: those who may fairly and reasonably be considered as arising naturally, that is in accordance to the normal course of things, which the claimants have said that they received only USD 109,000, but it was still not sufficient. What sort of expenditure occurred, Honorable Tribunal, that it was not sufficient? They did not mention in their emails, they did not mention in their arguments, it was not even mentioned in the agreement, it was not mentioned in the case file. They had not mentioned it in the email either, which fulfills the second element of the Hadley versus Baxendale case's remoteness of damage, that those were arising from exceptional circumstances which were communicated at the time of the contract. They then argue today that they could have spent the money in other ventures, and then we ask you, Honorable Tribunal, that why had they not informed us about this? Because according to Hadley versus Baxendale, as well as Section 73 of the Contract Act, it clearly states that such losses should be communicated to the respondent at the earliest possible time. So was held by Ewan McKendrick, Cheshire Fifoot and Firmstone, D.F. Mullah, and Treatle, contract law scholars, as well as the English decision of Simpson versus London Northwestern Rally, etc. Hence, both the claims of losses fall under remoteness of damage. And I lastly state, Honorable Tribunal, that them not stating about any loss, it fails to fulfill clause 3 of Section 55 of Contract Act, which states when time is of the essence and contract was not performed in due time, you may get compensation provided that you communicated this at the time it had agreed. On 2 May, on learned tribunal, on 2 June, in the email, they did not mention about any such thing. Therefore, based on the legal precedents and the arguments that we have cited, we would ask for 7 relief from this tribunal, which will be supplemented further in our direct and cross-examination. To declare, first of all, five things: that the tribunal has the jurisdiction to hear the dispute and will take into account the current laws in force in UAE and Bangladesh, the international law obligations of UAE and Bangladesh, and the principles of equity to settle the matter amicably. Declare that delay in paying the full amount was non-deliberate and caused by factors beyond our control. Declare that the respondent acted in good faith in course of the action and ensured performance of their obligation under the agreement to the extent possible. Declare that time is not of the essence of this agreement. Declare that the damages claimed by the claimant due to delay in payment are remote and were not communicated by us earlier. Order for renegotiation between the parties to come to a consensus on the new date of the remainder of payment, and ask us to amend the clause on prompt payment without further communication, since such problems may occur in future due to the banking difficulties as mentioned earlier. And lastly, Honorable Tribunal, declare that we have no obligation other than paying the due amount of USD 107,000, and that each party bear their own legal expenses and be jointly liable equally for all the fees payable to this tribunal, as the honorable claimants have outlined. If the Honorable Tribunal has no queries regarding our opening arguments, may we please proceed to direct examination of our 2 witnesses.
Yes, Mr. Ali Mashraf, please proceed.
I would now like to give the floor to Ms. Bushra Haq to conduct the direct examination of our 2 witnesses.
With the kind permission of the Honorable Chairman of the Tribunal, may I
Yes.
have some questions, please? Honorable Chairman of the Tribunal.
Yes.
Thank you, Mr. Chairman. Um, uh, I have, in fact, three questions to the learned counsel appearing on behalf of the respondent. If I can refer you to page um, sorry, page 5. Page 5 of your response to the notice of arbitration. What I understood from your submission is that you are requesting the tribunal to rely on two, or in fact three different substantive laws: substantive law of Bangladesh, substantive law of UAE, and international law obligations. So
Yes.
if I do not consider the international obligations for the time being, at least you, as per your request, you need to rely on two different substantive laws, Bangladesh and UAE.
Yes, Your
Do,
Honorable Tribunal.
do you think this is a viable argument? Because uh, in order to assess the liability of a party whatsoever, reliance of two different substantive laws is viable. And in case you think it is viable, do you have any reference of any arbitration, intrastate party or international, where the tribunal has in fact relied on two different substantive laws?
Honorable Tribunal, we are aware of the fact that while determining the essence of the dispute and in determining the damages and in order to award anything by a tribunal will not at the end of the day pay heed to two different jurisdictions of two different countries. We are aware of the fact. What we had mentioned at the very beginning is while trying to determine the nature of obligations by the honorable respondent side, that to consider our explanation of UAE civil code and UAE's commercial code, because the elements of good faith and the elements of contractual obligations are also contained therein. So we supplemented our arguments in relation to the Bangladeshi laws as well. If your Honorable Tribunal is aware, we mentioned Bangladeshi laws, the Contract Act. At the same time, we mentioned UAE Civil Code, so that our entire argument could be supplemented strongly and well. However, while if Honorable Tribunal had heard me earlier, while on the issue of damages, claims, remoteness of damages, we stuck to the Contract Act of Bangladesh. And earlier, we also stated that we are aware of the claimant's argument that we would go ahead with the Arbitration Act 2001 because Section 3 applies to this dispute. So yes, we went ahead with UAE laws for persuasiveness. And at the same time, the BIAC rules 2019 also says that the tribunal can look into other laws and usage of trade applicable in order to settle a dispute amicably. There are no hard and bound laws mentioned in the BIAC arbitration rules. And that is why we mentioned laws of two countries.
So from your submissions now, what I understood that primarily the substantive law here should be the contract law of this country, of Bangladesh.
Of Bangladesh, yes, Honorable.
For my clarification, you have mentioned the additional laws of UAE in the form of persuasive arguments, if I am not wrong.
Yes, and supplementing Contract Act provisions as well. Yes.
That I understood. And then the next question that I would like to ask regarding the argument of mistake, and if I refer you to page 3 of your arguments on behalf of the respondent, you have mentioned that the respondent, your client, was not aware of the time taken for clearance purposes, and your non-performance of your part, you're trying to characterize it as a mistake. My question is, before entering into an agreement with any party, you need to have a proper research about the laws of this country and the commercial practices. From your argument, at least it is clear that you are unaware of the practice. So do you really think it is a mistake or it is negligence because you haven't done your homework properly. Without doing your homework properly, without actually knowing the commercial practice of this country or Bangladesh, you have entered into an agreement with a company of that country. So your characterization of this unawareness as mistake, it may be termed as maybe misleading. Do you have any comment on that?
Honorable Tribunal, thank you so much. First of all, we looked into the specific law, and the BACH clearinghouse, Bangladesh automated clearinghouse, their procedures mentioned that it will be cleared by 10 a.m. the following day. However, the actual practice was not communicated by us earlier, and we are unaware and unable to actually go on and see such practices unless we actually get into the process. And that is why, while the law is there itself, which states by the next day, 10 a.m., the payment will be cleared, the actual practice was different. And secondly, Honorable Tribunal, as we have mentioned under this argument, that UAE was under the FATF Financial Action Task Force list, and they entered into this list later into April 2020, and thereby these payments were getting blocked under the AML CFT guidelines. Hence, when this procedure started,
Counsel, I would like to interfere. Knowing about the law of the host state is important, but knowing about the practice of the host state is also important. Whenever you are entering into a contract of a particular company of the host state, knowing about the commercial practice of that country is also important, because there are the commercial laws are complex and there may be many things written, but the actual practice may be a slight different. And in proper investigation to that practice is a duty of the investigating state or of the state entering into a contract or any party, and that is also a commercial best practice. So what is your comment on that? I understand that you inquired the law, but did you take any type of legal consultation or advice from lawyers of that country before entering into that contract, whether the time mentioned in your agreement was proper or not?
Honorable Tribunal, at the beginning, when we had looked into BIDA's website for investment, as well as every other, as well as the agreement and the BFTN rules, everything seemed very clear to us. When 2 to 3 official documents mention a certain timeline, we were aware that this would not take longer. However, Honorable Tribunal, as we have already stated in our argument, and we will further state this in our direct examination, the BFTN rules and everything, etc., as well as UAE being on the Financial Action Task Force list, occurred after April 2020, as we have already stated in our exhibits 11 to E13. And our counsel assisted us as much as possible, because that is the reason why, after being on UAE's FATF list, we started to send funds as quickly as possible. And that is why we sent 9,000 earlier, so that they do not find any inconveniences, and then started to send other amounts so that they could not have any inconveniences at any point whatsoever. This will further be clarified in our direct examination of our witness, Mr. Abdel Nadir.
My last question to you, if I may take you to page 10 of your arguments, and in your prayer portion, at the very end of your prayer portion, you have requested the tribunal, clause 6.6 of your prayer portion, you have requested the tribunal to order for negotiation between the parties. Yes. Why should the tribunal do that? Do you have any specific commitment that when can you actually make the payment? You haven't submitted any such commitment before the tribunal, because still the payment is due, in my understanding. So rather than asking for further negotiation, because the tribunal is going to award something, they're not going to award a negotiation. So do you have any specific commitment that when actually can you make the payment?
Thank you, Honorable Tribunal. First of all, this specific negotiation that we are seeking from this Honorable Tribunal is because, yes, we have a certain date. We intend to send the money as soon as possible, because we have already sent the money from our own bank. It is now being barred due to the AML CFT guidelines. So only what needs is the clearing from Bangladesh bank's end, first of all. And second of all, the very reason we ask for this negotiation is because this is only 2,16,000 payment. There is a payment of 54,000 left. This business has a lot of further payments left. So at any point in future, because for the next 1 year, UAE will be under the FATF watch list, it will take further delays in future again. So the clause for payment promptly without further communication, if that is amended, if the tribunal asks us to amend this clause in future when we have similar problems, as I said, due to being on the FATF task force list, so that we do not come to this tribunal again for a civil dispute and that we have to delay our time and involve lawyers and costs. That is the reason for negotiation. And
But
the
what
payment
is
has
the
already been.
I haven't heard any commitment. Like, what is your
Hon-
submission before the tribunal
Honorable
regarding
Tribunal,
the time frame?
the time frame is it's already been sent from our end, as we have mentioned in our argument as well as our email chains. The payment is just entering into Bangladesh jurisdiction and awaiting clearance from Bangladesh Bank. And now that we have Mr. Abdel Nadir here as our witness, as well as both the parties are aware that the payment is stuck in Bangladesh Bank's end, this will only take negotiation to just clear it out right now. And the government will also help us because it is a party to this project.
Okay, nothing further for me. Thank you very much.
Honorable Chair, can we move on to the direct examination of our witnesses now?
Yes, just a minute. You had a written contract with the complainant.
Yes, Honorable Tribunal.
Was there any place mentioned in the contract as to the place of arbitration?
Honorable Tribunal, the place of arbitration was not mentioned, but we had mentioned that the BIAC, we would refer such disputes to BIAC, and as such, the BIAC rules are being followed, and hence we are coming to this particular tribunal for settling this dispute under the BIAC Arbitration Rules 2019.
Thank you.
Most welcome, Honorable
And
Tribunal.
then, whether in the payment term, there were any clause or provision for extension of time.
Honorable Tribunal, in the specific agreement on allowances, there was no specific provision for extending time, but the official email from the claimant, Mr. Tariq Ahmed, to the respondent on June 2, 2020 specifically mentioned that they were extending the time for payment, and they did not mention anything about losses that they had incurred earlier or any cost for which we might have been aware that due to delay, they were incurring expenditures or incurring losses. So the 2 June email indeed extended the time for payment.
Yes, you mentioned email, and we find some email messages from your side too. And
yes,
we find some inconsistencies between two email messages from your side. While you are in one message is telling him that I have already paid your money, and in another message you told him, okay, wait for some time, I am arranging money. So these email messages not complacent to each other.
Honorable Tribunal, that is not the fact in the case. We have, as we have mentioned in the first email, the money was sent. What we meant by that is the money has left UAE's bank as in the process of getting into Bangladesh. The payment was stopped from Bangladesh bank's end, and that is the reason why we emailed them that we are looking into the matter, we are arranging into the matter. And then, as we have provided in our exhibits, we contacted bank manager Mr. Abdel Nadir in Bangladesh to ask him what had happened and why the payment did not reach the claimant, because we have already sent the payment all along. So those are consistent in their messages.
Yes. Any question from my brother arbitrator?
No, Honorable Chairman.
Any more question?
Nothing further from me, Honorable Chairman.
No question.
Honorable Chairman, if you permit, I would like to start the direct examination of my first witness.
Okay. Proceed.
For the record, please state your name.
I am Abdul Hannan, Director of Business Development of Brooks Fire Engineering Industries, LLC.
Mr. Hannan, if you travel to 25th of April of this year, do you remember receiving any contractual amount from the project?
As per the contract with the project, we received the full contractual amount, We are to pay the local agent USD 216,000 in accordance with the agreement concluded with them on 5th of July.
Have you informed the local agent regarding the acceptance of this payment?
On 26th April, the very next day, we emailed the local agent acknowledging the payment. We also assured them to pay their due within the stipulated time.
Mr. Hannan, you obviously know the reason of today's dispute. When did you get to know about the delay in receiving money by the claimant?
On 10th May, after receiving the email from the claimant, I became aware of the fact.
And what did you do afterwards?
I instantly checked the transaction details and got to know that the transaction was made on 2nd May. I replied to the claimant on 12th as 11th was Saturday. After that, I emailed the bank asking them about the transaction.
Please mention the details of the transaction that you have just talked about.
So after checking the details, I got to know only 100,000 was transferred. I didn't look into the transaction before, as that's the job of the accounts division. But after I received the email, I myself promptly looked into the transaction details to find out about the partial payment.
Why did you only pay partial amount of 100,000 US dollars and not the full?
It was done by the accounts department. On 14th, I called a meeting with the company's representative, Mr. Sudipto Bhattacharya, and accounts head. Accounts head explained to me about the recent ongoing issues of UAE being under the FATF watch list. On hearing the news, I asked them to make the due payment transferred as soon as possible.
Was the local agent aware of the reason of the delay?
I emailed describing the unintentional oversight, banking issues, limited working hours, and public holidays for non-clearance on 17th May. I have also mentioned to communicate further if anything else is required.
Mr. Hannan, during this entire chain of communication with the claimant, was there ever any mention of any losses and damages incurred by them?
No, they did not make any communication regarding this, even when I asked them, and I was relieved when no communication was made regarding the losses.
From your statement, it is seen that the last communication was made on 17. When was the next communication with the claimant made?
I received another formal email on 30th May acknowledging the received amount of 100,000 USD, to which we replied back on the next day, explaining the hardship of our situation and asking for more time.
Did the claimant give you more time?
They understood our inability to pay and extended the deadline to pay the remaining amount by 5th of June.
Did the claimant receive this due amount by 5th of June?
After my direction on 14th May, the accounts division transferred another 9,000 USD, a small amount since the previous one had not been received by the claimant despite the passing of a good amount of time.
Mr. Hannan, did you inform the claimant about the transfer of the outstanding payment too?
We emailed the claimant telling them that our hands are tied and we are doing our best to make the transaction as soon as possible. We have also repeatedly emailed the bank telling them that the delay might make us face legal action.
You have used the term legal action. Did you let the bank know in details the reason for the transfer and why you might face legal action?
No, we couldn't tell the bank anything in details, as that would have been a breach of the confidentiality clause as per our agreements with the local agent.
What was the bank's response to your repeated email to make speedy transaction?
The bank told us it's happening due to administrative issues and gave us assurance that they will solve the matter as soon as possible.
Thank you, Mr. Hannan. You can go now. If the Honorable Tribunal permits, I would like to move to the direct examination of my second witness.
Yes.
Thank you. Can you please state your name for the record?
My name is Abid Nadir.
And what is your job?
I'm the manager at Tejgaon branch of Golden Bank Limited.
Mr. Nadir, was any transaction made by the Brooks Fire Engineering Industries on 2nd May?
Yes, on 2nd May, Brooks Fire Engineering Industries made a telegraphic transfer of 100,000 US dollars to Mega Drive Limited. This transaction was cleared on 30th May 2020.
Does it usually take this long for such transactions to be cleared? Mr. Nadir, are you there?
On paper, in accordance with the Bangladesh. Yes, I can hear you. On paper, in accordance with the Bangladesh Electronic Fund Transfer Network rules, the Bangladesh Automated Clearing House is supposed to clear such transactions by 10 a.m. the following day. But on 2nd May 2020, it was a Saturday, a weekly holiday in Bangladesh. Hence, the transfer was registered on the following day, the 3rd May. The transfer, therefore, theoretically is supposed to be cleared by 10 a.m. Monday on 4th May.
Mr. Nadir, you have used the terms like on paper and theoretically to describe how long it takes for such transactions to be cleared. Why is that?
Unfortunately, due to the slow nature of paperwork clearance, in actual practice, such clearing takes minimum of 10 to 15 days, depending on the amount transferred and the parties involved. The pace is even slower during Ramadan, as office hours are decreased during that time. Bank operations were closed from 23rd May to 26th May. Many of our staff were on leave for extended period, all of which added to the delay.
Mr. Nadir, was there any other transfer made from the Mega Drive Limited?
Yes, there were two transfers made, one on 4th June 2020, another one on 7th July 2020.
Was the transfer on 7th July cleared?
No, the third transfer on 7th July was not cleared.
And why it hasn't been cleared yet?
Our bank found the transaction suspicious and hence reported it to the Central Control Unit.
Why did your bank find the transaction suspicious?
As you know, the United Arab Emirates is on the watch list of the Financial Action Task Force from April 2020. The reason why such transactions felt unusual was that this company was for the first time involved in a project in the country. And due to the UAE being on the FATF watch list and our legal obligations, our bank thought of being safe than sorry.
What happens if a transaction is thought to be suspicious by a bank?
If a transaction is thought to be suspicious by a bank, the legal obligations of a bank under the Bangladesh Anti-Terrorism Act 2009 and as per the Anti-Money Laundering and Countering Financing of Terrorism Guidelines 2015 issued by Bangladesh Bank, we are to check the KYC profile of the client. And if the transactions are felt to be of unusual nature, banks then report it to the Central Control Unit.
What happens after a transaction is reported to the Central Control Unit?
Under the MLCFT guidelines, after CCU receives the report of an unusual transaction, it sends it to the Bangladesh Financial Intelligence Unit for investigation. Only after the BFIU completes its investigation and if the transaction receives a green light, can the transaction be cleared.
Mr. Nadir, you have from your statement, you have mentioned that you know Mr. Hannan. Can you tell me if Mr. Hannan communicated with you regarding the third transfer?
Yes, Mr. Hannan emailed me on 8th July and 9th July to inquire as to why the transaction has not been cleared yet.
Did you tell Mr. Hannan that his transaction was under investigation by the Bangladesh Financial Intelligence Unit?
No, under the MLCFT guidelines 2015, banks are under a legal obligation not to tip off clients about such investigations. Therefore, we could not inform Mr. Hannan why the delay was occurring.
So what did you tell Mr. Hannan?
I told him that due to specific administrative and legal procedures, his transaction was still tied up under the jurisdiction of Bangladesh Bank. Hence, his transfer was not yet cleared.
Mr. Nadir, if you haven't told Mr. Hannan the real reason, why are you saying all this now?
After Mr. Hannan asked me to be a witness in this arbitration proceedings, our management discussing this with our in-house counsel came to a conclusion that I can divulge this information before this tribunal, as we now know the full details and as to the cause of the transaction, and as arbitration proceedings are confidential, will not be violating any legal obligations.
Mr. Nadi, my last question to you is, during this course of your communication with Mr. Hanlan regarding the transfers, did he give you details at any time why this was so urgent?
No, he only mentioned his company would face legal consequences, but never divulged the information as to why the funds were transferred. Also, in telegraphic transfer applications, only the account holder's name and account numbers are mentioned, so we could not get much details.
Thank you, Mr. Nadi. That's all for you. Honorable Tribunal, I have presented the evidence in reference to the statement given by my witnesses in the exhibits. If the Honorable Tribunal is satisfied, I would like to call forward the other lawyers for the cross-examination.
Yes.
Thank you.
Cross-examination.
Yes, Honorable Tribunal, my Mr. Rahman is currently facing some network issues. He will be available shortly.
The respondent would like to cross-examine Mr. Tariq Ahmed. Should we proceed on, Mr. Chair and the members of the Arbitration Tribunal? Mr. Tariq Ahmed, how would you define your commercial relationship with Brooks Fire? Would it be correct to say that the Brooks Fire has been prompt in other previous financial transactions?
I'm sorry, can you repeat the question? I couldn't hear.
Mr. Tariq Ahmed, Brooks Fire has been prompt in other previous financial transactions. Would you agree?
The first transaction that they had with us, and they didn't pay the full amount.
We are referring to the transactions that has taken place in response to the project and before the payment.
As far as I know, that Brookfire has furnished a performance security to the project, but they never paid us anything.
Yes, but in response to that payment, was Brookfire prompt? Let me help you out with your written statement. You have mentioned that seeing the client's eager promptness in the 8 months, we have worked with them, as well as their swiftness in paying the performance security as requested by the project. On the very day the notification award was issued, we thought there would be no problems with our arrangement. So let me again ask you the question.
We were providing the service, but Brookfire was not prompt in their paying us.
But Brookfire in their previous transactions were prompt, right?
We didn't had any previous transactions with Brookfire. This is our first transaction and they didn't pay us.
But you are involved with the project as well. So in response to the project,
when they pay us, and I don't know anything about they paying the project, and that was a performance security.
You
they
didn't know about the performance project, performance security? Let me restate my question to you. Brookfire paid the performance security, right?
To whom?
To the project, for which you are taking the margin of 15% from us.
We are not taking the 15% margin from the performance security. We are taking the 15% margin from the payment that the project paid to Brookfire.
Yes, exactly. So in response to that project, which involved performance security to the project, was Brookfire prompt in paying the performance security?
They paid the project amount to the performance security amount to the project. Yeah.
Yes, and in your written statement, you have mentioned that they were prompt in those transactions. In page 2 of a written statement, the last paragraph, you have clearly mentioned that seeing the client's eager promptness in the 8 months we have worked with them. So you agree?
Yes, you paid to the project, right? The
yes.
performance security was paid to the project, and that was done within 1 month, within the deadline. And after that, we thought that we can.
Yes, but why are we prompt in that transaction? Yes or no?
We had the assurance that you would pay
Would you
us
kindly
on time.
stick to my question? Would you kindly stick to my question, dear witness? Why are we prompt in that transaction according to your own witness statement? Yes or no?
You were prompt in paying.
Thank you.
The project,
so if I move on
us.
from this one, you have always received all the replies to your formal request from us, right?
Can you repeat it?
The formal requests that you have sent to us in email, right? You have always received replies from us to those formal requests.
The replies didn't include any direct
Please
answers to the
answer
reason.
in yes or no, dear witness, Mr. Tariq Ahmed. You have sent us emails which are considered to be formal requests, right?
Yeah, the director replied to me.
So have you always received those replies from us?
Yes, I received it after we have emailed them a number of times. And
yes, but you have always received the replies, right? You have received all the replies to your formal requests.
The replies doesn't have any value if they
I'm asking
don't
yes or no. You have received all the replies, right?
Yes, we have received the replies.
Thank you. So in your formal request, the emails that you have mentioned, have you?
But Mr. Counsel, leading question is not allowed.
Mr. Chair, this is cross-examination, and I think I'm allowed to ask little questions.
And you should refrain from making leading questions.
Thank you, Mr. Chair. If I get back to my cross-examination to Mr. Tariq Ahmed, in your formal request, as in the emails, have you ever for once asked why there was a reason behind the delay?
Yes, I did.
Can you mention two instances in your written statement? Because we did not find anything in your written statement asking clearly if there was a delay, there was a reason for our delay in clear terms. While you get back to me on this one, may I proceed on with other questions? In your formal...
1 minute. I would like our coordinator to please screen share the email. The email chain.
Right.
Is there any more question?
I have 3 more questions here, Mr. Chair, if you permit me. May I proceed on
Can
with
the
those?
coordinator screen share the email chain?
Yes.
Yes, if we go to the last line, you're saying if you have a relevant reason to delay the payment, and then you are asking the question, perhaps we could come to an arrangement, but you're not clearly asking for the reason of the delay. It is a conditional statement, isn't it?
Can I answer your question?
Yes.
Coordinator, please go to the previous email. If you have a relevant reason to delay the payment, perhaps we could come to an arrangement to suit both parties.
Yes, but are you asking clearly if there is any relevant reason for the delay?
Learned counsel cross-examination, you should allow the witness to answer.
My apologies.
Learned counsel, you should.
My apologies, Mr. Rabbi. Yes.
This is a cross-examination, not an argument.
Thank you. What I stated was that if you have a relevant reason to delay the payment, perhaps we could come to an arrangement to suit both parties. And please, can you show me that where have you mentioned any particular reason that was the reason behind the delay? And have you asked our opinion that what suited our situation? No, you didn't.
Mr. Witness, I think I will be the one asking the questions. Have you clearly asked the reason for delay in anywhere in your formal replies?
What do you think I said here?
I'm asking you the question. Please answer.
Yes, I have.
Where?
But you cannot go beyond the contract.
Sorry, I couldn't hear.
I am asking if there was a clearly asked question about the reason for delay.
Yes, this is my question regarding the reason for delay. You asked me a question and I'm saying yes.
Was there any specific reason for delay?
Mr. Chair, we have already we have replied to our reasons for the delay, and we have clearly mentioned the oversight and banking difficulties that we have faced in all the emails. My submission regarding to this point was that in their any of the formal request or emails, they have not clearly ever asked us the reason for delay. What they have asked us is if there was any relevant reason, perhaps we could come to an agreement. So if I may move on, since the time of this tribunal is very short. Mr. Chair and
Yes.
the members of the tribunal. If we please get out of this screen sharing. So my next question is, in your formal emails, have you ever asked, mentioned about the damages you're facing?
Not receiving the money that someone owes us itself is an inconvenience.
Have you clearly ever mentioned? Yes or no?
I was under no obligation to let Brookfire LLC know about what losses are incurring.
That means you did not clearly mention about the damages you are facing, right?
Can you show me where Brookfire LLC exactly asked us that if we were, like, they didn't ask us about our losses and we were under no obligation to answer to that.
Okay, Mr. Counsel, time is over.
I have particular two questions regarding this. May I finish it up?
But you consumed 1 hour's time.
A lot of time was consumed with the screen sharing, Mr. Chair. If
there may be a lot of questions, but it must be put within a specific time.
Yes, if I please ask two more questions, Mr. Chair.
1 hour's time was allotted to you.
Mr. Chair, one more question, please.
One more question, okay?
Okay. In our email of May 30, we have asked you if you are facing any inconvenience, and as per your reply to June 2, you have talked to your directors and a lot of deliberation has taken place, but you clearly omitted to mention of your damages in that reply. Did you not?
No, I did not.
We clearly asked you if you are facing any inconveniences, but you did not reply to that.
Can I answer, please? You did not ask one time if we were facing any inconvenience. You didn't ask us. You just assumed that we were not facing any inconvenience and you would say it as an amount of payment. But you didn't ask us anything. And we are under no obligation to talk about our losses. But we did, in fact, incur losses. We have to pay our employees as well. And we couldn't do that.
So my last question to you is, having a previous transaction dealing with the bank, makes the transaction easier, right? Because you were able to ensure the bid with the project because you have previous dealing with the Dutch Bangla Bank.
Can you repeat the question?
You were able to help us with the bidding because you are able to ensure the bid money clearly. The reason was because you have previous dealing with the bank. So our question is, having previous dealing with the bank makes the transaction easier, right?
It was a bid bond, not money. It's not monetary.
In your witness statement, you have mentioned that
performance guarantee. It was a performance guarantee.
Yes.
Yeah, Mr. Chair, it was a bid bond of 5 million taka.
It was a bid bond. It's a document.
Okay, we are impressed. Thank you all.
No further questions, Mr. Chair and the tribunal members.
Thank you. Thank you very much.
Honorable panel, if I may.
The claimant side would like to request the panel for their cross-examination.
Now, as per schedule, Mr. Rumi Ali, he will come before us and I hand over the mic to him.
Sir, we have changed our schedule. Now, dear all, it will take 10 to 15 minutes to prepare our result. During these 10 minutes, two arbitrators, Mr. Asif and Mr. Rabbi, will deliver their feedbacks. And Mr. Asif, floor is yours.
Okay.
The
Barrister Asif, floor is yours. Please give some feedbacks to the participants. Barrister Asif, can you hear me? So we can move to Mr. Rabbi. Can you please deliver the feedback?
Yes, out of so many papers, I'm trying to find out the respondents' score for respondent team.
Hello. Can everyone hear me?
Yes, we
Hello.
can hear you.
Yeah, both teams have performed a very lively debate in this arbitration. I would like to point few things as my feedback. For the claimant team, Mr. Nafiz Imtiaz Araf, you have taken too much time on the governing law and arbitration jurisdiction. May I remind you that the governing law and the jurisdiction is not in dispute. It is not disputed by the respondent. So you took a lot of time in explaining and submitting in relation to governing law and dispute. Another point is the validity of the contract is also not disputed. So you spend quite some times in there as well. The interest accrued, and then you calculate the entire amount and add as a total amount. So you should have made a table on your particulars of claim. So that's all. That's my feedback.
Mr. Monzur Rabbi.
Thank you very much. I think it's a very lively session between two very well prepared team. Regarding feedback, the only point I'm trying to I mentioned that when you cross-examine, because the cross-examination part was sounding like a little bit of argumentative. So when you cross-examine, can you hear me properly? When
Yes, we can hear you.
When you cross-examine a witness, it's important that you show proper respect to the witness. It's very important because, like you obviously you need to attack the witness with your question, you need to throw your questions to the witness, but at the same time, like you should be very careful that whether you do not sound very attacking, that they may look a little bad, and at the same time, you should allow your witness to answer your questions. That is my observation. And also, like for the witness also, like when you answer a question, even if the counsel is trying to, like to some extent, provoke you with his questions, you be calm and quiet and you stick to your answers. Do not question back. Like it is you understand. So as you are new in this area, I think a lot of things to develop. But now I enjoyed the session. But that is the point I try to make, because cross examinations are questions and answers. They are not this is not the time to argument between you two. That is the point. And also, in terms of answering questions to the tribunals, I think both the parties have done pretty well. But make sure when you answer a question when you receive a question from the chairman or any other arbitrator, you receive the question first politely, and then you start answering. Sometimes I have observed that some of you are like in a hurry to answer. Yeah, it happens to us as well sometimes. But the best practice is that you be calm and quiet to receive the questions politely first from the tribunal, and then you will start your answer. You understand? So I have done. I'm quite amazed that you have done it quite properly. Maybe there are some areas to develop, but I'm really happy to see you all today. Thank you for me.
Today we have with us BIAC's director, Mr. Hossain Azad, who was a civil servant official and retired as Additional Secretary, Ministry of Agriculture, Government of Bangladesh. Now may I request Ahmad sir to say a few words for our students.
Thank you. Good afternoon, Honorable Chairman of the Indian University Arbitration Contest Tribunal, Mr. Justice Abdus Salam Mamun. It's my privilege to be with you during this unique occasion where students gathered together at the first round of the first ever arbitration contest of this type initiated by BIAC in presence of the two other members of the tribunal, Barrister alias Asif Khan and Barrister Monzur Rabbi, and our CEO, Mr. Muhammad Irumi Ali. As you all know, Bangladesh has now Hello? Should I start afresh? Hello?
Yes, sir, we can hear you.
So I should continue or I should start from the beginning?
Sir, continue.
Okay. As you know, as we all know, that Bangladesh has now lofty dreams of becoming an upper middle income country in 2031, fueled by the present government's Vision 2021 and achieving sustainable development goals by 2030. We also plan to become a developed country after 2041. But how to achieve these goals? The World Bank's Doing Business Global Index 2020 said we stand 168th among 190 countries. Though we have been up by 8 notches from the previous year, we have to go a long way since we are lagging far behind in one of the most important of the 10 indices of enforcing contracts. We are 189th out of 190 economies. So it is very important to ensure enforcing mutual commercial contracts for overall economic development of the country. In our country, it takes 1,442 days for resolving any commercial dispute through a local first instance court, whereas it takes 3 times less in the OECD high income countries, which is around 590 days. What can be the breakthrough? Now, we talk much about ADR in 2020, where there are 3.7 million cases still pending in the courts. But 20 years before, we are not aware, even most of us did not hear the terminology of alternative dispute resolution. Who came up to solve the issues, to contribute to an economic development by enforcing contract? It is the business organization, including the International Chamber of Commerce Bangladesh, the Dhaka Chamber of Commerce, the Metropolitan Chamber of Commerce, and one of the eminent businessmen and leader of the business community, Mr. Rahman, who is chairman of BIAC and as well as president of International Chamber of Commerce Bangladesh. He had the vision of creating a new forum to integrate with the court system so that things are done well and promptly with cost effectiveness so that we can prosper, our economy can grow. And he tried his best along with other leading business organizations, and they took license from the government to establish Bangladesh International Arbitration Center. You have heard about us from our opening speaker, the GM, who said why BIAC is needed. And actually, we started business in 2011. Less than 10 years or so, we are proceeding with our goals. What is our goal? It's not only to facilitate arbitration mediation. We have outreach programs, trainings, and motivation activities. You have heard about all this a while ago. To achieve our targets, we have our own mediation, arbitration and mediation rules, and a panel of arbitrators consisting of 11 eminent jurists, among whom 4 are former Chief Justices of Bangladesh. 47 experts and trained mediators are in our list of mediators. We have developed all the facilities required for systematic and comfortable arbitration and mediation, and has handled 294 ADR hearings till date. Under the leadership of Mr. Rahman and our Chief Executive Officer, Mr. Muhammad Ruby Ali, who has been with us as CEO for around 5 years or so, is a renowned banker who headed the Standard Chartered Bank, who was Deputy Governor of Bangladesh Bank. We are trying hard to make BIAC the hub of ADR in Bangladesh with a view to acclimatizing all concerned and stakeholders about an alternative route to save time and settle outside of the court commercial disputes so that our economy can grow, we can achieve our target, we can attract more FDIs, and finally, we can graduate ourselves to a developed country as targeted by 2041. Much have been spoken about the norms and practices of ADR, how to even acclimatize our students with the ADR mechanism so that they can be future leaders in different sectors, from the government to the judiciary, from the legal fraternity to the corporate world. Today's deliberation and the thought-provoking arbitration competition is a pathway to start with. I wish the students community will also join us to popularize, to adhere to the norms and practices of ADR in the coming days. Let ADR be the order of the day. I am very much thankful, and I express our gratitude to our Honorable Chairman of today's Arbitration Tribunal, Mr. Justice M.A. Salam Mamun, and his colleagues, Barrister Asif and Monzur Rabbi, for their time and handling this unique event so efficiently, so energizingly. And I'm also thankful to the authorities and students and participants of London College of Legal Studies South and University of Dhaka for making this event successful. Thank you all. Allah Hafiz.
Now I would request Chairman of the Tribunal, Mr. Justice Abdus Salam Mamun sir, to deliver. I repeat, I would request Chairman of the Tribunal, Mr. Justice Abdus Salam Mamun, sir, to deliver his feedback to our students and announce the result later.
Mute. I have given you, do you hear me, please?
Yes, sir. We can hear you.
Yeah, yes, please. So, because the computer was not working properly and I could not use my own, so I have sent my escort to your mail. You can kindly,
Yes, sir.
you can
Yes,
kindly
sir.
pick up.
We received.
Oh, you received. Okay. Okay. Now about the performance of of both the parties. I'm to say that their performance is excellent. Arguments put forward by both the teams are of real standard, and we can appreciate them for placing their cases and respective cases, and for their pleadings, and also for their cross-examinations. It is indeed, I did not notice how 2 hours has lapsed because of the lively presentation and their arguments in the arbitration proceeding. I am so happy with the proceeding, with the hearing, and I suppose the other 2 arbitrators also enjoyed it and also saw their skill and their way of presentation, mode of presentation, and they are also pleased.
Sir, I had an inquiry, if I may.
Yes.
Since this was like the first time that BIAC has hosted an arbitration,
Yes.
I had an inquiry as to when the claimant side was supposed to do their cross-examination.
You are to know what about cross-examination.
As in, at which point of time were we supposed to go do the cross-examination? I'm a bit confused as to that point.
Cross-examination was held, and both parties presented their witnesses, and their learned counsels cross-examined them. Mr. Hossain, appearing for the claimant, he was examined, and the respondent also presented witness. He was also cross-examined. Anything more?
No, sir.
Sir, the main issue was that we were not able to cross-examine the witness.
Sorry, you were not able to cross-examine.
Yeah, we were not able to cross-examine the respondent's witness. Sir, the main issue was that we were not able to cross-examine the witness.
Respondent produced their witness. Sorry, you were not able to cross-examine.
Sir, if I may interrupt. Sir, we thought we would do the cross-examination after the respondent side did their chief examination.
Yes.
Not before that. So we were not given the chance to do the cross-examination, sir.
Yes, yes, that was the procedure. But
yes, sir.
When the respondent's counsel came forward, we asked them whether they will place their case first or they will cross-examine the witness. They agreed to place their case first and then to cross-examination. So
Yes,
I agree.
sir. Yes, sir. But sir, we wanted to do the cross-examination after they put forward their own chief examination, sir.
Mr. Hossain has examined in chief.
Sorry, sir. We wanted.
Sir, what we would like to clarify is right after the respondent had done their chief, they directly went to cross-examination. We did not get the chance to cross-examine their witnesses. That is what we were trying to say.
Cross-examination of the claimant's witness?
No, sir. The respondent's witness, sir.
The respondent's witness. Yes, the respondent witness was Mr.
Mr. Hanan.
Mr. Hanan.
Mr. Abdul Rahman. I need to talk to my two arbitrators. The arbitrators, please.
Yes, Mr. Chairman. To answer that question, at what stage should you cross-examine? The answer is you should cross-examine after the examination of chief of the witness of the respondent.
Yes.
But
yes.
due to the time constraint, you only get 60 minutes to finish it all up. So I guess it's a bit difficult for both of the teams to finish their within minutes time period. So yes, unfortunately, you could not cross-examine the witness of the respondent. But the process is after after the examination in chief is done on part of the respondent, then you get the opportunity to cross-examine the witness of the respondent with the leave of the court or
Sir.
in this case, with the leave of the tribunal.
Sir, if I may humbly.
Does that answer your question?
Yes, just a minute. We have allotted 2 hours time.
Yes.
1 hour for each party. You have to conclude your part within the appointed time fixed for you. We found that you have consumed your time. Examination is over in the examination hall.
Exactly.
Respected arbitrators, if I may say something.
Yes, please.
Respected arbitrators, we were supposed to do the cross-examination after the respondents had done their chief. So we had made the application. Mamun Chaudhary, who is the third claimant lawyer, she made the application to the arbitration panel that we would like to do the cross. Now, sir, nothing was said about this. Furthermore, we were not given a time check as to when we should do our cross-examination as well. So we are sort of confused regarding the order of things. So we thought that.
Thank you for clarifying the information.
The order is as follows. You open your statement. First of all, to your particular case, but you spend, as I said before, you spend, the team LCLS spends so much time on governing law and jurisdiction, which is not disputed in this case. Had it been disputed by the respondent, then you could have an argument as to whether the jurisdiction of Bangladeshi law and rules apply is disputed. You have requested by notice of arbitration, you have requested for the arbitration. They have replied that they have submitted to the jurisdiction as per the agreement. And specify arbitration jurisdiction is under the BIAC rules. So there is no dispute. But you kept on going as to the jurisdiction and the arbitration rules. Another point is where you have spent so much time unnecessarily is the capacity to enter into a contract. You spend almost 7 minutes. That you could have done a cross examination within 7 minutes, right?
I see.
So you went on submitting about the capacity and validity of the contract, which is not disputed either. Is that disputed by the respondent? Whether a contract was executed or not? It was executed. It's right there. You have signed. Both parties have signed a contract, and they have already responded to that in your through their reply to the notice. Reply to your note.
Yes. Thank you, sir. Sir, one last query.
You have to give yourself enough time. You have to structure your argument in such a way so that you can finish it off within the allocated time. And in court, when you graduate, when you enroll yourself as an advocate, you will see that we get barely 5 to 10 minutes to place a motion. So you may know everything about the case, but you do not say everything about the case. You structure your argument, you structure your evidence, you structure your annexures, and you constantly refer to the annexure. So facts, relevant annexures, legal argument, supporting case law. That should be your structure. Is that clear?
Yes, sir.
Yes,
thank
sir.
you, sir.
Thank you for your clarification, sir.
So now we can conclude the proceeding. Mr. Arbitrators?
Yes, Honorable Chairman, please.
We can conclude the proceeding?
Yes, please.
So the arbitration proceeding is concluded here. And
Sir, we have sent the result to your phone.
This one?
Sorry, sir?
To this phone?
Yes, sir.
Okay. Just a minute, I have to go. Where? Message or somewhere else?
Sir, I have sent the SMS to your phone number.
SMS,
Ji.
SMS, okay. Yes, thank you. I got it. So I'm going to declare the score of the teams participated in this arbitral proceeding. Claimant team, the group has scored in total 87, and group total score of respondents, Dhaka University, is 120. Winning team is Dhaka University. Am I clear to all?
Team Dhaka University.
Am I?
Thank you so much,
to the winning
Honorable
team
Tribunal.
as well. But to the team LCLS South, with the permission of the chairman, I would like to say you didn't do your cross-examination. So that is one of the reasons that that the number gap is that much. But I think you have done very well. Like if you could do your cross-examination, I think that your portion will be substantiated more.
Well, gentlemen, one thing to remind you, you have to be within time. Otherwise, you will be out of time.
Yeah, I agree with the Honorable Chairman of the Tribunal.
Yes. Thank you very much.
Congratulations to the team of University of Dhaka, and thank you to the team of LCLS South. You guys did a very good job. Better luck next time. I would like to conclude the session by thanking the chairman and members of the tribunal and the team members of the University of Dhaka and the London College of Legal Studies, along with their faculty members who worked hard to train up and prepare their students for this contest. Dear all, I'm Rahman, General Manager of BIAC, was your host and coordinator of this contest. Thank you all joining us online. Thank you.
Thank you very much.
Thank you. Thank you, everyone. Thank you, Bangladesh International Arbitration Center, for giving us the opportunity to participate in this wonderful arbitration contest. And I wish both the teams good luck for their future. And I would like to thank our Honorable Chairman of the Tribunal and my co-arbitrator, Mr. Monzur, Rabbi, for this contest. Thank you.
Thank you.
Thank you to the tribunal and thank you to LCLS for such a wonderful round, and thank you to BIAC for organizing this, and to all members of the tribunal for their valuable feedback. Assalamu alaikum.